What if I told you that behind the glittering world of red carpets and flashing cameras, a single missing audio file could turn an entire courtroom upside down tonight? We uncover the mystery that everyone tried to bury, the secrets that waited. In silence and the shocking twist that nobody saw coming, stay with me, because what you are about to hear changes everything. In the heart of the city where headlines are born and reputations tremble, a story began to unfold that would make even the most seasoned reporter hold their breath, because when one name echoing through Hollywood corridors collided with whispers of hidden recordings and sealed evidence, curiosity transformed into chaos. They said there was an audio file, a simple recording made in quiet confidence that somehow held the power to ignite a storm inside the courtroom. It was said to capture words spoken in secrecy, conversations that were never meant to see daylight. But when the attorneys walked into the courthouse, at the very end of the day, when the halls had gone silent and the clerks were preparing to lock the doors, they dropped a revelation so unexpected it left everyone wondering what had been hidden all along. They revealed that the mysterious audio, the one at the center of so much speculation, had never actually been filed with the court. No one had heard it. Not the judge, not the jury, not even the clerk. And yet it had been spoken about as if it was the very core of the case. The letter from the attorneys arrived like a spark in dry grass, confirming that the file was missing, confirming that something so crucial had been absent from the record. The judge had already unsealed the mention of the audio, and questions were pouring in from journalists and the public. But when he asked to review it, there was nothing to hear and nothing to see. The attorneys responded saying they would finally provide it, but not digitally, not through the modern systems of electronic filing. Instead, they chose a method that seemed to belong to another time. They said they would burn the audio onto physical compact discs and hand them to the court clerk to distribute to the public upon request. It sounded almost surreal, like a scene from an old mystery movie where the truth was locked away, not in code, but in plastic discs. The plan was simple. Or so they said. Anyone could request a copy. Anyone could pay a small fee and receive a disc with the audio inside. But this choice raised more questions than answers. Why wait so long? Why hide behind physical media when everything else lived online? And why did it seem that every move was made just a few steps behind the truth in court? Every document has a purpose. Every filing tells a story. So when the most crucial piece of evidence is missing, the silence becomes louder than any argument. The attorneys explained that the court docket could not technically handle an upload of the audio file, that it had to be provided physically. Yet those who understood the system knew that digital submission was not only possible, but common. The reason for the delay was left hanging in the air, unanswered. As the clock ticked toward the next deadline, the judge ordered that the physical copy be handed in no later than Monday, October 20th. And until that day arrived, speculation consumed the internet. The public wanted to know what was on the recording and whether it truly contained the shocking statements rumored to exist. Every thread of conversation online carried the same electric charge. What was in that file? Why had it been kept away for so long, and most of all, who stood to gain from its silence? People spoke of chain of custody, of authenticity, of whether the voices on that tape were real or staged. Lawyers debated on panels about admissibility and hearsay, while fans and followers turned the story into a digital treasure hunt somewhere in New York. A clerk was preparing to receive a disc that could decide reputations, careers, and perhaps even freedom, and somewhere else. Someone whispered that maybe the truth was never meant to be found at all. As the day of submission drew near, the sense of suspense thickened like fog over the courthouse steps. Each new update from the attorneys only deepened the mystery, because it wasn't just about the recording anymore. It was about what it symbolized: trust, credibility, and the fine line between legal truth and public perception. When something so vital vanishes from the official record, it forces everyone to wonder if the system itself can be trusted. And that is where our story begins. As Monday approached, the courthouse became the center of quiet anticipation. People moved through the marble hallways, whispering about the disc that was supposed to arrive. Some said it was already there, locked away in a file room guarded by protocol and procedure. Others said the attorneys were still preparing it, sealing it with the kind of precision that made it sound like a treasure chest being closed. The strange part was that nobody seemed to know the truth. Even the judge had not heard it, and that silence created a vacuum that the internet was eager to fill. There were rumors that the recording contained the voice of someone powerful discussing plans to ruin another reputation. There were theories that it was simply a misunderstanding, that the file was less about scandal and more about miscommunication. Yet the energy surrounding it was undeniable. Because whenever something is hidden, the world assumes it must be extraordinary. The legal experts who followed the case reminded everyone that authenticity was everything, that before the court could even listen to the file, it needed to be proven genuine. The process was supposed to include sworn statements, descriptions of how the recording was made when it was created, and how it had been stored since then. Without that verification, the recording might be meaningless. It could be dismissed as inadmissible hearsay. But in the court of public opinion, truth is not always decided by rules of evidence. It is decided by emotion, by curiosity, and by the fear of what might be lurking in the unknown. As the story unfolded, the attorneys for both sides confirmed that the disc would not be uploaded online. Instead, it would be handed to the clerk and distributed upon requests. That meant that only a few people would have access at first, and those few would control the narrative. The thought of that power unsettled many, because in an age where everything spreads in seconds, the idea of waiting for a physical copy felt almost strategic, almost intentional. It was as if they wanted to slow the story down to control the tempo of the truth. The decision to use a CD instead of a digital upload sparked endless commentary. Why revert to old technology when high-resolution secure file transfers existed? Why make it harder for the public to access information that was supposed to be transparent? Some believed it was caution. Others said it was calculation, because if fewer people could hear it, fewer could question it still. The deadline loomed, and speculation only grew when Monday morning arrived. A few dedicated watchers gathered near the courthouse hoping to see something. Anything, perhaps a box carried inside, perhaps a courier with a small envelope. Marked confidential reporters refreshed their phones waiting for a statement, but none came, and that silence felt louder than any announcement. Eventually, a quiet confirmation surfaced from someone close to the case saying, yes, the disc had been delivered. Yes, the clerk now held it. And yes, requests could soon be made. That tiny piece of information reignited the frenzy within hours. Message boards and social networks buzzed with talk about who would be first to hear it. Names were mentioned. People who lived nearby who promised to go to the clerk's office in person. Some offered to share the recording online once they obtained it, and others warned them to be careful because even sharing it could invite legal trouble since the original. Consent around the recording remained in question. The irony was heavy. The file that was supposed to bring clarity now brought confusion. The evidence that was meant to support a case now raised questions about legality and motive, and amid all of this, one truth remained unspoken. Perhaps the act of holding the recording back was more powerful than the recording itself. Because mystery is the most persuasive storyteller of all, while the public speculated, the attorneys on both sides exchanged formal letters confirming the logistics, confirming how many copies would be made, confirming that everything was done according to procedure. But behind those formalities was the tension of trust. How could anyone trust a process that left even the judge in the dark? How could a court move forward when its own evidence was incomplete? Legal analysts began comparing this case to others throughout history, where missing or delayed evidence had shifted the balance of justice, and what they found was chilling. In every story where information was withheld, even for legitimate reasons, the outcome was forever shadowed by doubt. So here, once again, doubt began to bloom like ink spreading through water. There was talk about how once the CD was made public, it could either confirm or collapse the claims within the lawsuit. Some said it might expose a coordinated plan. Others said it would reveal nothing of consequence, but no matter what it contained, the recording had already done its damage, because it changed how people looked at the players involved. No one could see them without wondering what was really said in that conversation, and no one could hear their names without remembering the missing file as Monday turned into evening, and the city lights flickered against the courthouse windows. Those who followed the story closely felt a strange mix of excitement and fatigue. Excitement because the mystery was finally taking shape. Fatigue because the truth seemed to move slower than anyone expected. It was as if the case existed in two worlds, one made of facts and filings, and another made of whispers and wonder. And right between them sat the CD spinning silently somewhere, waiting to be heard. The question that lingered was whether hearing it would bring resolution or just deeper confusion, because sometimes the truth does not heal. It divides, and those who chase it find that clarity is not always what it seems. And as the courthouse lights dimmed, one last time that day, one thing became clear. The story was no longer just about the audio. It was about power control and the fragile balance between secrecy and exposure. As the story reached the middle of its tangled path, The air around the courthouse seemed heavier than before, because now everyone had a theory, and no two theories matched. Some said the delay was intentional, that someone somewhere wanted to stretch the suspense until the very edge of belief. Others said it was nothing more than bureaucracy and technical limitations, that in the end, the disc would reveal nothing more than a conversation taken out of context. But even the skeptics could not deny how strange it was that something so ordinary had turned into something that captivated thousands. What began as a legal filing had evolved into a cultural moment, the kind of story that thrived on uncertainty, where every new whisper became a clue and every unanswered question became proof of a larger secret. The longer the file remained unheard, the stronger the speculation grew. People online began charting timelines, building theories about who recorded it, why it was made, and whether the conversation inside even existed in the way it had been described. The digital age had turned into a detective board filled with strings connecting names and dates and filings, each person sure that they alone had uncovered the missing piece. But inside the courtroom, where reality still mattered, the judge remained focused on one thing: the rule of evidence, because no matter how viral a story becomes, the law moves with precision and patience before the audio could ever make its way into a trial. It would have to be authenticated, proven to be genuine and relevant, and that meant affidavits, chain of custody, and verification, none of which had yet appeared on the record. The lawyers for the opposing side remained quiet, perhaps too quiet, and their silence added another layer of intrigue. Maybe they knew something that the public did not. Maybe they were waiting for the moment when the excitement turned against itself. The use of a physical CD rather than an electronic file made the process slower and more complicated, and some began to wonder if that was the plan all along. After all, in a world that thrives on instant information, delay is its own form of power, because the longer the truth is withheld, the more people fill the void with imagination, and imagination can be far more persuasive than facts. Even the way the letter had been written fed into the tension. It was polite, formal, respectful, and yet between every line there was a quiet sense of urgency, as if even the attorneys themselves wanted the responsibility of the file to be passed on to someone else. By giving the CD to the clerk, they were removing themselves from the equation. They could say it was no longer in their hands, no longer their burden or their risk. And that detail did not go unnoticed by observers. Many pointed out that by routing the release through the clerk, they insulated themselves from any legal question regarding consent or legality of the recording. Because if anyone challenged its release, it would be the court that handled it, not them. It was a clever move, whether intentional or not, and it reinforced the idea that this story was no longer just about evidence, it was about strategy and perception. On the morning after the submission deadline, news spread that a few people had already made requests for copies of the CD. One person claimed to have driven hours to reach the courthouse. First, another said they were willing to pay any amount for the first copy, and somewhere online a countdown had begun, people waiting for the moment it would surface. Someone even posted that they planned to record the playback and share it publicly, though others cautioned that doing so might breach legal rules. The debate itself became part of the story, fueling more engagement, more curiosity, more speculation. Meanwhile, in the courthouse archives, the seed sat quietly cataloged and labeled, a small object now carrying the weight of a very large narrative. And what was perhaps most fascinating of all was that nobody still knew whether the contents of the recording would even be admissible in court before a judge could allow it to be presented. It would have to survive multiple legal tests: authenticity, relevance, legality, and without that certification, it would remain what it was: a piece of unverified material attached to a motion that had not yet been ruled upon. And yet, in the minds of the audience, it had already become evidence-proof confirmation of everything they wanted to believe, that contradiction between law and perception was the real conflict at the heart of the story. Because while the courtroom demanded facts, the public demanded drama, and both worlds were colliding under the same roof. Somewhere in all of this, one truth remained painfully clear: whoever had created the recording, whoever had kept it hidden, and whoever had chosen to reveal it now stood at the center of a spotlight. They could not escape the silence around them had become deafening. Every move, every filing, every statement was analyzed by thousands, and every moment of hesitation was taken as proof of guilt or fear. As more days passed without any leak of the audio, frustration grew online. People wanted to hear it, not read about it. They wanted to decide for themselves what it contained. But still, the court process crawled forward like time itself, refusing to be rushed. Because in law, timing is as important as truth. And sometimes timing is the only thing that decides how truth is remembered by now. The story had become more than a lawsuit. It was a test of credibility, a study in modern storytelling, and a reflection of how easily silence can create noise. As the days turned into weeks and the world kept watching, the case began to evolve in unexpected ways, because once an audience tastes mystery, it never lets go. What had begun as a legal filing had now transformed into something that felt like a serialized drama unfolding in real time. Every update from the courthouse was analyzed, dissected, debated, and sometimes distorted for clicks and attention. But underneath the noise, the truth still waited hidden within that single disc sitting. In the custody of the court, some people speculated that the delay in releasing the copies was intentional, that the parties involved wanted to test how far the story could spread before the recording itself emerged. Others said the process was simply slow, because bureaucracy moves with its own rhythm. Still, every new development added another twist, because it was no longer about who said what. It was about who controlled the story. The tension between the parties intensified, though their official statements remained polished and calm behind closed doors, each side prepared for the next phase, the motions, the filings, the hearings, and the responses, because that is what law does. It builds walls of procedure around emotion so that facts can stand on their own. But the public was not interested in walls. They wanted revelation. They wanted the moment when someone would finally press play and let the truth pour out like light in a dark room online. Commentators described what they imagined was in the audio. Some said it held admissions. Others claimed it contained laughter, cold and detached, as if mocking those who believed in justice. Some said it was proof of innocence. Others believed it was the final nail in a reputation, already cracking, but all these ideas were born from imagination, not evidence. And yet imagination is powerful enough to shape perception. Soon discussions spread to whether the court could even use the file if it had been recorded without consent. Questions about privacy, legality, and ethics collided in endless threads and debates. Experts explained that even if a recording exists, it does not always mean it can be used in trial, because it must pass through a series of gates before it becomes evidence, relevance, authenticity, and admissibility. These were the keys, and without them, even the most explosive sound could mean nothing. The judge, meanwhile, focused on other matters related to the case. He reminded everyone that this story was part of something larger, a network of filings, motions, and consolidated claims involving multiple parties, including organizations that had already been dismissed but still lingered in the paperwork waiting for resolution. The attorneys were ordered to clarify what motions remained open and whether or not the cases were considered final. The judge made clear that consolidation did not erase individuality. Each case still stood alone, even when combined for convenience, and this technical detail became another source of confusion for those outside the legal world. People wanted a clear ending, but the legal process refused to provide one. Not yet, because in reality, closure does not come with applause. It comes with documentation and approval. Stamps. The media reported that the deadline for delivering the physical audio had been met, and that the clerk now held it securely, but they also reported that copies would be distributed only upon formal request, meaning no one would hear it unless they took that step. And while most people waited for someone else to make the effort, one name began circulating online, a person known only by a username promising to visit the courthouse in person, to obtain the disc and share it with the world. They were seen as a digital hero by some and a reckless risk-taker by others, because while the desire for truth was noble, sharing restricted material without authorization could have serious consequences. But the promise was made. The countdown began, and the entire internet waited. The question was no longer whether the audio was real. The question was whether the world was ready to hear it, and whether those who wanted to expose it truly understood the weight of what they were about to unleash, because sometimes the truth, when revealed, does not bring peace. It brings chaos. And as the date drew near for the public to finally access the audio, the courthouse stood quietly like a stage before the curtain rises, filled with the energy of anticipation and the haunting awareness that once the sound escapes, it can never be silenced again. And then the moment everyone had been waiting for finally began to unfold, though not in the way anyone expected, because when the first members of the public arrived at the courthouse to request the audio, they found themselves entangled in a process far more complicated than they had imagined. Forms had to be filled, Payments had to be made, and the clerk had to verify each request before handing over a copy. Some who came hoping for instant access were turned away, told to return later, and that delay created yet another wave of speculation. Was it an accident, or was someone trying to buy more time? Eventually, the first copies were released, small silver discs sealed in plain envelopes, each labeled with a case number and a date. And from there, the story began to fracture, because every person who received a copy became a storyteller of their own. One said the recording was clear and shocking. Another claimed it was distorted and incomplete. Another said it contained nothing of interest at all. The contradictions only deepened the mystery, because now there was not one version of the truth. There were many, and nobody knew which one was real by the time the first unofficial summaries of the audio appeared online. The story had grown beyond the control of its creators. The details blurred between fact and speculation. People quoted lines that may or may not have existed, and analysts on video platforms debated every supposed sentence, every tone, every pause. The case that had started in quiet legal filing rooms now existed everywhere, across screens, across headlines, across conversations. And yet, in the center of all that noise, the real legal process continued, methodically, unaffected by the storm outside, because the court does not move according to public fascination. It moves according to evidence and order within the court. The attorneys argued motions about fees and damages. The judge questioned the finality of earlier dismissals and requested clarification from every party about what remained unresolved for all the spectacle surrounding the audio. It had not yet been ruled admissible. It was still only an exhibit attached to a motion awaiting review, and that distinction meant everything. But outside those walls, the world did not care. They had already written their verdict, because when people want a story to mean something, they do not wait for facts. They fill the silence with conviction and call it truth. As more people obtained copies of the seed, the technology itself became part of the conversation. Why use a medium so outdated in an era of instant sharing? Some joked that it was symbolism, a reflection of how justice itself sometimes feels trapped in the past. Others said it was a tactic, a deliberate choice to make access harder, to slow the spread of whatever truth it carried. And though none of these theories were proven, they persisted, because speculation once ignited is nearly impossible to extinguish by now. The narrative had taken on a life of its own. Influencers, analysts, and commentators each offered their take, some measured and cautious, others dramatic and certain, and through it all, the people at the center of the story said very little. Their silence now interpreted as strategy or fear, depending on who was watching. Eventually, the judge issued further instructions clarifying that all remaining motions must be addressed before any case could be formally closed, and that the presence of pending fee requests meant the matter was not yet final. The law had its rhythm, and no amount of noise could rush it, but still outside the courthouse cameras waited, voices echoed, and anticipation refused to die. The CD now existed in the world, its contents debated, but its meaning undecided. And perhaps that was the greatest twist of all, that after all the waiting, all the tension, and all the theories, the truth still belonged to no one. Not yet, because in the end, the story had become larger than the recording, larger than the case, larger even than the people involved. It had become a reflection of us, our hunger for mystery, our impatience with silence, our belief that hearing something ourselves will finally make us understand, when in reality it only opens more questions. The courthouse returned to its routine. The clerks continued their work, and yet the air still carried the residue of what had happened, because once a story like this escapes into the world, it never truly ends. It just fades until the next spark reignites it once again. And so, besties, what began as a simple question about an audio file became something far greater. A story about how truth can hide in plain sight, how silence can speak louder than words, and how curiosity can build entire worlds from fragments of uncertainty. The case itself may continue for months, perhaps years, with motions and filings and hearings stretching toward resolutions that feel both distant and inevitable. But what remains unforgettable is the way a single missing disc captured global attention. It reminded us that transparency and secrecy are not opposites, but twins forever, pulling against each other. That sometimes the answers we seek are not locked away in hidden evidence, but in our own reaction to not knowing. Because mystery feeds imagination, and imagination feeds obsession. And when we chase stories like this, we discover that we are not only searching for the truth about others, we are searching for what truth means to us.